Bankruptcy trustee presses case against ex-Colorado star Shilo Sanders. The bankruptcy case surrounding former Colorado defensive back Shilo Sanders has taken on a heavier, more consequential tone as the court-appointed trustee moved aggressively this week to keep the case alive, pushing back against claims that he misunderstood the flow of money tied to Sanders' name, image, and likeness earnings. In a filing dated December 17th, the trustee laid out his rebuttal in plain, forceful language, arguing that Sanders violated bankruptcy law by transferring roughly $250,000 to himself without authorization, money the trustee believes should belong to the bankruptcy estate rather than to Sanders personally. It is the latest escalation in a legal battle that has followed Sanders since he sought Chapter 7 bankruptcy protection in October 2023, attempting to wipe away more than $11 million in debt that traces back to a civil court judgment in Texas. What began as a procedural effort to collect and distribute assets has evolved into a deeper dispute over timing, control, and credibility, with each side painting a starkly different picture of what those funds represent and who is entitled to them. At the center of the dispute is the trustee's role itself. David Wadsworth, appointed by the court to administer Sanders' bankruptcy estate, is tasked with identifying and collecting non-exempt assets that can be distributed to creditors. According to Wadsworth, that job has been anything but straightforward. In October, he filed a lawsuit against Sanders seeking to recover money he traced to business accounts connected to Sanders' nil activities, as well as a full accounting of those funds. Those entities, Big 21 and Headache Gang, were named alongside Sanders as defendants. The trustee alleges that Sanders exercised improper control over assets that should have been preserved for the estate, transferring funds to himself without court approval. Sanders' legal team responded a month later by filing a motion to dismiss, arguing the trustee's claims were fundamentally flawed and based on a misunderstanding of the nature of the earnings. That argument is now squarely contested, with the trustee's attorney calling it demonstrably wrong and urging the court to allow the case to move forward. The crux of the disagreement hinges on a deceptively simple question that carries enormous financial consequences. When did the money actually belong to Shilo Sanders, and when did it belong to his creditors? Under bankruptcy law, earnings generated before a debtor files for bankruptcy typically become property of the bankruptcy estate, while income earned from services performed after the filing generally belongs to the debtor. Sanders' attorney has argued that the funds at issue fall into the latter category, describing them as post-petition earnings that Sanders was entitled to keep. The trustee, however, disputes that characterization and insists the matter cannot be resolved at this early stage because it depends on factual determinations that go beyond what is appropriate for a motion to dismiss. In his filing, the trustee's attorney emphasized that Sanders' defense relies on assertions not established in the complaint and therefore should not be accepted as fact by the court. In one particularly pointed section of the filing, the trustee's attorney challenged the notion that all the money in question was generated after Sanders filed for bankruptcy. He noted that there were already funds sitting in the Big 21 bank account on the day the bankruptcy petition was filed, undercutting the argument that the account consisted solely of post-petition earnings. In a footnote that cut sharply against Sanders' position, the filing stated that because funds existed in the account on the petition date, the defendant's argument was demonstrably wrong. That detail, while technical, strikes at the heart of the defense and suggests that at least some portion of the money may be subject to turnover to the estate. The trustee also raised a broader legal point that further complicates Sanders' argument. Even if certain payments were received after the bankruptcy filing, they may still be considered pre-petition earnings if they stemmed from contractual rights that existed before Sanders sought bankruptcy protection. In other words, the timing of when money hits an account does not necessarily determine who owns it. If the right to receive that money arose from agreements signed before the bankruptcy filing, the trustee argues, then those funds could still belong to the estate. The filing states that it is more than plausible that at least some of the post-petition deposits were based on Sanders' pre-petition nil contracts and therefore subject to turnover. That plausibility, the trustee contends, is enough to allow the lawsuit to proceed and for the facts to be developed through discovery. Beyond the legal technicalities, the trustee's filing paints a picture of frustration. suggesting that Sanders improperly exercised control over property that should have been safeguarded for creditors and failed to provide a full accounting of distributions made from the business accounts. The trustee is not merely seeking repayment of the disputed funds, but also transparency, asking the court to require Sanders to explain how the money moved and where it ultimately went. A bankruptcy judge will decide whether the trustee's complaint survives the motion to dismiss, a ruling that could shape the trajectory of the case and determine whether Sanders faces deeper scrutiny into his finances. The backdrop to all of this is a civil judgment that has loomed over Sanders for years. The debt at the center of the bankruptcy case stems from a lawsuit filed in Dallas by a school security guard, John Darjean, who accused Sanders of causing permanent and severe injuries during an altercation in 2015. When Sanders was 15 years old, Darjean alleged that Sanders injured him while resisting the confiscation of a cell phone at school. Sanders' parents were initially named in the suit but were dismissed before trial. When the case finally went to trial in 2022, Sanders did not appear, and the court entered a default judgment against him totaling $11.89 million. Darjean began efforts to collect on that judgment in 2023, prompting Sanders to file for bankruptcy protection in an attempt to escape the crushing financial liability. That effort, however, is far from resolved. Darjean has filed a separate complaint in the bankruptcy case arguing that the debt should not be discharged because it arose from a willful and malicious injury, a category of debt that bankruptcy law often excludes from discharge. Sanders has countered by claiming he acted in self-defense. That dispute remains pending, as does another complaint from Darjean accusing Sanders of improperly omitting or concealing assets in his bankruptcy filings, allegations Sanders has denied. Taken together, the overlapping legal battles have transformed Sanders' bankruptcy case into a complex, multi-front fight that extends well beyond a routine effort to resolve debt. All of this unfolds as Sanders' football career has come to an abrupt halt. Once a high-profile college player who followed his father, Deion Sanders, from Jackson State to Colorado, Shilo Sanders is now 25 and out of the NFL after being waived by the Tampa Bay Buccaneers before the season. In recent comments, he said he was moving to Miami and exploring other pursuits, including acting and rap music, signaling a desire to redefine himself beyond football. He completed his undergraduate degree at Jackson State and later earned a master's degree in organizational leadership at Colorado, credentials that suggest preparation for life after the game, even as the legal challenges persist. Sanders occupies a unique place in one of football's most famous families. He is the middle son of Deion Sanders, a Hall of Famer whose larger-than-life persona has shaped modern college football, and the older brother of Shedeur Sanders, now the quarterback of the Cleveland Browns. That lineage has amplified public interest in Shilo's case, turning what might otherwise be an obscure bankruptcy dispute into a closely watched legal saga. Each filing, each motion, and each rebuttal carries weight not only because of the dollars involved, but because of what it suggests about accountability, responsibility, and the lingering consequences of past actions. As the trustee presses forward, the case stands at a pivotal moment. If the court agrees that the trustee's allegations are sufficiently supported, Sanders could be compelled to open his books, return disputed funds, and confront deeper questions about his financial conduct. If the motion to dismiss succeeds, it would represent a significant victory for Sanders and narrow the scope of the trustee's reach. Either way, the outcome will reverberate through a case that has already spanned years and crossed the boundaries between sports, law, and personal reckoning. For Shilo Sanders, the fight is no longer about tackles or playing time, but about ownership, timing, and whether the past can be disentangled from the future under the unforgiving lens of bankruptcy court.